Imagine finding out that your employer has been taking screenshots of your personal computer, the one you own, the one sitting in your home, every 5 minutes, around the clock, for 7 months. And when you confront management about it, their response isn't panic or remorse. It's essentially, "Yeah, we know. We just forgot to update the paperwork." That's not a hypothetical. That's exactly what happened to one IT worker in Texas, and the legal fallout from this situation could be catastrophic for the company involved. Today we're breaking down exactly what happened, why it matters, and what rights you have if something like this is happening to you right now. Let's set the scene. Since the pandemic, millions of Americans shifted to working from home. Companies scrambled to adapt, rolling out remote work policies, VPN access, and software tools that allowed employees to keep doing their jobs from personal devices. For a lot of workers, that meant downloading company-approved programs onto computers they personally purchased, computers that also contain their private emails, their banking information, their personal photos, their medical records, their private conversations. Most employees accepted this as a reasonable trade-off. You use your personal machine as a workstation. You follow the company's IT requirements, and in return, you get to work from home. What most people did not agree to, and what most people would never knowingly agree to, was allowing their employer to take a photograph of their screen every 5 minutes, including late at night when they're doing things that have absolutely nothing to do with work. In Texas, that's exactly what was happening to an entire workforce, and almost nobody knew about it. Here's how the story unfolded. The employee at the center of this story works in IT for a company that, like so many others, went fully remote during COVID. Over the past several months, this IT worker started noticing something that didn't sit right. After some digging, they discovered that the company had been using a piece of software called ActiveTrack, a productivity monitoring tool, and had bundled it silently into a routine update package that employees were required to download onto their personal computers. Here's the key detail that makes this situation so alarming. The update was deliberately designed as a one-click install. The reason given internally was simple convenience. They didn't want employees flooding the IT department with questions. But the consequence of that design choice was that the end-user license agreement, the EULA, the very document that would have disclosed what the software actually does, was skipped entirely. Nobody saw it, nobody agreed to it. It just installed quietly in the background and started doing its job, which was taking still images of whatever was on the screen every 5 minutes. The IT worker confirmed something even more troubling when they went back through all of the company's internal documentation. Employment agreements, handbook acknowledgments, onboarding paperwork. None of it contained any language giving the company permission to take screenshots of employee devices. The only monitoring consent the employees had signed related to phone call recordings, which is a completely separate matter. There was no written policy, no disclosed terms, no checkbox, no signature, nothing. When this employee brought the issue to their manager, the response was jaw-dropping in its casualness. The manager acknowledged that yes, the company was aware there was no signed consent. They had planned to update the employee handbook last year to include this policy, but simply forgot. The plan now was to add the language in November and have everyone sign it then. As if the 7 months of secret, unconsented screenshots were just a minor administrative oversight. The IT worker pushed back. If no consent was obtained, then all the data already collected is a serious legal problem. The images need to be purged. The manager disagreed. The screenshots were actively being used by local managers to monitor employee productivity, and deleting them was off the table. What came next is where things got deeply uncomfortable. The IT worker was given access to the repository where all these screenshots were stored. They started clicking through folders at random, and what they found went far beyond anything the company had intended them to see. Some of the computers being monitored were clearly personal purchases with no official company markings. The timestamps on the images showed that screenshots were being taken at all hours, 3 in the morning, on weekends, during hours that had absolutely nothing to do with work. And the content of those screenshots? The IT worker chose to be deliberately vague about specifics, but the implication was clear. They saw things on those screens that were deeply private. Websites people visited in the middle of the night, on their own personal time, on their own personal machines, in what they believed was the complete privacy of their own home. Information that no employer has any business possessing. The manager's reaction to the off-hours monitoring was telling. He seemed genuinely surprised and somewhat alarmed. Not that the screenshots existed without consent, but that they were capturing activity outside of work hours. He instructed the IT worker to delete the images taken before 8 in the morning and after 5 in the evening. He also told this employee to keep quiet about everything they had seen, on the basis that their IT access had given them visibility into something they weren't supposed to find. The plan going forward from the company's perspective was to quietly patch the software to stop capturing screenshots outside business hours, then update the handbook in November, and treat the whole episode as resolved. No disclosure to employees, no acknowledgement that their personal devices had been monitored without consent, no conversation about the data that was already collected. The IT worker, understandably, was not satisfied with this resolution, and they were right not to be. So let's talk about what the law actually says here, because this situation raises serious red flags on multiple fronts. In Texas, like in most states, covert computer monitoring without consent can run into significant legal trouble. The Federal Electronic Communications Privacy Act, along with the Stored Communications Act, places restrictions on intercepting or accessing electronic communications without authorization. When you're monitoring someone's personal computer, not a company-issued device, but a machine the employee owns, and you're doing it without their knowledge or consent, you are operating in very dangerous legal territory. The fact that employees were required to install software on their personal devices does not automatically grant the employer the right to monitor everything on those devices. The standard expectation is that if monitoring is going to occur, it must be disclosed. Most employment attorneys will tell you that for a monitoring policy to hold up legally, it needs to be clearly stated in writing, acknowledged by employees with a signature, and reasonably limited in scope. None of those conditions were met here. The off-hours monitoring adds another layer of exposure. Even in workplaces where some degree of employee monitoring is legally permissible, capturing activity on personal devices during non-work hours is a much harder case to defend. Courts have consistently recognized that employees retain privacy interests outside of their working hours, and monitoring personal devices during those periods dramatically increases legal liability. Now, what about the IT worker specifically? They raised an important question themselves. Does the fact that they discovered the images and deleted some of them create any personal legal exposure? The short answer, based on what they described, is probably not. They were acting within the scope of their authorized access when they found the repository, and deleting data at a manager's instruction while potentially complicating any future litigation is not something they initiated or benefited from. They did not plant the software, they did not authorize its deployment, and they raised the alarm rather than covering it up. That matters. For the company, the exposure here is serious. Potential violations of federal computer privacy law, potential violations of state wiretapping or interception statutes, civil liability to employees whose private data was captured without consent, and depending on what was actually captured on those screens, there could be additional complications around sensitive personal information. If this ever reaches litigation, the fact that management was informed, acknowledged the lack of consent, and chose to quietly patch the problem rather than disclose it to employees is going to look very bad in front of a jury. So what can you learn from this situation if you're working from home right now? First, take a hard look at what's installed on your personal computer. If your employer required you to install any software or connect through a VPN, look up every application that was bundled with those installations. Tools like ActiveTrack are not secret. You can search for them and find out exactly what they do. Check your task manager or activity monitor for programs running in the background that you don't recognize. Second, review every document you've signed with your employer. Look specifically for any language about monitoring, recording, or data collection. If there's nothing there, that's important to know. Third, if you discover that your employer has been monitoring your personal device without your consent, do not delete anything and do not stay quiet. Document what you found, when you found it, and who you told. Consult an employment attorney before taking any other action. Many offer free initial consultations, and this is exactly the kind of situation where having professional legal advice before you respond is essential. Fourth, be thoughtful about what you do on a personal device that you also use for work. This isn't to excuse what this company did. It was wrong, and it was likely illegal. But the practical reality is that the lines between personal and professional have blurred significantly in the remote work era, and protecting your own privacy requires active attention. If this happened to you, if you've discovered that your employer has been monitoring your personal device without your knowledge or consent, you likely have legal options, and you should explore them. The fact that a company forgot to update a handbook does not make 7 months of secret surveillance acceptable, and courts have consistently recognized that employees have real privacy rights worth protecting. If you found this breakdown helpful, please consider subscribing. We cover real legal situations that affect real working people, and new videos go up every week. Hit the notification bell so you don't miss what's coming next.